Good afternoon, everyone. My name is Rahul Sharma, and I'm founder of the Perspective in Grade Ace. We provide technology policy and data protection advisory and consultancy services. Especially thankful to Manoj sir and Cocoon for giving this opportunity to talk about DPDPA. Now, we have seen over the past few months when DPDPA rolled out, you would have in various conferences and sessions heard about different provisions, what are the good and bad side of DPDPA, what are the new things, what are the things that we need to take care of, what is the compliance angle, etc. So I just tried to touch upon some of the different aspects that haven't been fully covered, but yes, in some parts they have been, and something that we couldn't cover in the last session evening. Okay. So, in accordance with the title of the session, we start with the jubilation. What forms the jubilation? Why should we jubilate it with the DPDPA happening? First of all, we must all congratulate ourselves because it's been a long, hard-drawn effort to formulate a data protection law. And in the next slide, I will explain to you briefly what the history has been. Mr. Bhartuhari Mehta, member of Lok Sabha, when this bill was getting passed, he made a comment that it's better to have an uncle with one eye than having no uncle at all. In this same vein, not having an ideal data protection law is much better than having no data protection law at all. It's a manifestation of India's digital journey. Its economic, national security, data protection concerns, what are its outlooks towards having relationship with other countries, what are the different arrangements and relationships that are getting formed with use of data, data processing, and data protection as a theme. As someone said, it is one of the most important laws to be passed in the independent India, and it is going to have a very long-lasting effect. So, as we were discussing about the history, the journey started 13 years ago when the government formed a privacy approach paper. Then in 2011, Justice A.P. Shah group of experts was formed which reported on the privacy principles. It's still available in public domain if you want to read what was the thinking then, what was the outlook then on data protection, how things have changed since. In 2014, a draft data protection bill was leaked, which was formulated by Department of Personnel and Training. But since the government changed, there has been fresh outlook on how the data protection law has to be conceived, thought about, and then enacted. In 2017, you would famously recall the Puttaswamy judgment, which gave effect to right to privacy as a fundamental human right that the constitutional and through the Supreme Court acknowledged. So all the laws, frameworks had to keep in consonance with according privacy as a fundamental right to every Indian in this country. After the Supreme Court judgment, the Sri Krishna Committee report came up with this report on what should an ideal data privacy or data protection framework should look like. And it was a pretty wide consultative, facilitative work which involved inputs from various stakeholders. But the law that was presented pretty much modeled around GDPR. And as you would see, since then, there have been 5 versions that have been presented. But with every subsequent version, there is a significant departure from looking like a GDPR or GDPR look-like law. So after the Justice Sri Krishna Committee, MeitY formed 3 data protection bills. It was first tabled in 2019, and then it was immediately tabled to the Joint Parliamentary Committee. Joint Parliamentary Committee, in my view, is one of the most exhaustive and fantastic works which provided very insightful, often far-reaching and overreaching with respect to data protection, but very insightful comments and observations on what a data protection law should cater to, what are the things that need to observe. Some of the recommendations of JPC, which was in fact led by the majority BJP parliamentarians, Some of them were considered, but even the JPC recommendations you would not find being reflected in the law which is being passed. So there has been a significant change in the approach and thinking on how we should formulate our data protection law, which I think is a very important aspect. And finally, as you know, the bill got enacted on 11th August 2023. 10 years, nothing happened, different drafts were tabled, but in just a week, both houses of the parliament got the law cleared. We got the Gazette notification, President assent, and then it became a law. So what about the twinge? So because there were significant departures from what data protection law was being conceived at and what we were deliberating. So most of the 10 years deliberations almost went down the drain because there was a completely fresh outlook on how data protection law was being thought and conceived, which was reflected in the 2011 draft. And I think that was a very important aspect because the exemptions, the rule-making powers that was being delegated to the government, that brought about a significant change on how it differs from various other global data protection laws. What about the reticence? So there was a lot of buzz around data protection privacy, when the law will come, what will happen, this will happen. But when the law actually came, there was an absolute silence. Despite significant departures from the earlier positions, community did not speak up. There were hardly any discussions happening on what the data protection law is. Is it actually the right path? Because it happened such in a hurry. In 1 week, everything got enacted because people weren't expecting, because it took more than 10 years. But then what explains the reticence? It's also because I think some people who were involved from the very inceptions got exhausted. Some people thought that this is the right way to go. And some people thought that let's give it a try. Not having a law is better than having no law at all. And I just added this title, disarray. It's not in the subject title, but yes, disarray is also important because the companies went into disarray. One, because the law is enacted, but the rules aren't notified. There is no effective date of enforcement, although the Minister Rajiv Chandrasekhar in his talks has said that it will have an effect since the date of enactment. So for example, if your company data got breached after 11th of August 2023, it will still take into consideration when the Data Protection Board sees the case, what the matter is. So organizations have to be very careful. They should not think that when the date will be there for enactment, then only the enforcement starts. Enforcement has already started. It is just not being legally and institutionally being practiced because there is no mechanism. You would have seen the reason for disarray is also the wide range of exemptions which were provided in the Act for notified agencies, and in the panel we were discussing on the instrumentalities of the government. What is that is still not known. For research, archiving and statistical purposes, for startups and other notified categories of data fiduciaries. This is something Minister Ashwini Vaishnav and Mr. Rajiv Chandrasekhar repeatedly emphasized, that we do not want a data protection law which becomes a barrier and inhibitor to the growth of startups. This is slightly learning from the lessons of Europe's GDPR, where the startups in the data ecosystem companies have been complaining about having such a tight ecosystem that the companies find difficult to flourish, but also to the fact that the outlook towards how a data protection law should be formed has changed. So in the previous versions of the law, the preamble clearly spelled out data protection as a priority. However, if you look at this law, which got enacted, it emphasizes data processing legalization as a priority, which balances the data privacy rights of individual and the organization obligations. So that's a complete shift on how this was conceived and drawn. Also important is the number 7 part on exempting foreigners' data which is coming to India through contract being exempted. Now that allows any company outside to sign any contract with Indian company with any data processing requirements, which could also entail abuse, to be included as part of the data processing requirement. And since it is legally exempted under DPDPA, there is no actual legal recourse which will be available. So this is again a loophole, which other countries have also been pointing out. For approved merger, demergers, we could have seen the startup space. Every other day there is some merger, demerger, movements happening between companies. So it's very important that just the prospect of merger, demergers do not result into data protection violations, and that being provided sort of an exemption. And to locate defaulters and their financial assets. Now, you would have seen in the case of fast loan apps where the contacts and galleries are being copied by these companies and then being shared with the relatives, often morphed pics being shared or abusive calls being made to the relatives. That is not allowed, but for recovery purposes, still there is an exemption. Something that we could not cover in yesterday's thing, which is on cross-border data flows. The bill importantly reversed the paradigm of international data rules, because so far we have seen models of how the data flows have to be restricted. And you could have seen that in all the versions of the data protection bill which India came up with. Data localization, data sovereignty was a key theme on how they were enacted, on how they were perceived of. But when this version came out, it completely changed the outlook. The 2022 draft, just 9 months back, said the government is going to have a whitelisting approach. What does it mean? That any data fiduciary in India cannot transfer data to any company outside India unless that country is in a list of whitelisted countries as notified by the Indian government. But just within 9 months, the paradigm reversed and whitelist became blacklist. So now any company can transfer data outside India unless the country is not in the blacklist. 180-degree turn on the position. But what are its implications? So now India will have a permanent negative list on which countries will move in and out, unless we have a predefined list of China, Pakistan, North Korea, Syria. A criteria has to be defined, basis which the companies has to be adjudicated whether they will form in the negative list or not. And it's a permanent list, so countries will move in and out. So that is like declaring who your data enemies are, where the data cannot be transferred to the data fiduciaries. These things also will have long-lasting geopolitical implications. That's why I said it's one of the most important bills, and whatever provisions get enacted through these laws will have far-reaching consequences in every sphere, not just data processing, but also geopolitical. How does DPDPA contrast with GDPR and other global laws? And companies, I've heard companies say, oh, we are GDPR compliant, so like we don't need to worry about DPDPA. It's anyway a much refined version of GDPR. But there are significant departures. So I'll just list some of them. On data categorization, GDPR case to categorize data, what is sensitive data, what is personal data, etc. But here it is just one category, personal data, that's it, no sensitive categories. If you remember in the 2018 draft, we had personal data, we had sensitive personal data, we had critical data, but now all that is done away with, just one category. The data fiduciary classification. Here, interestingly, DPDPA takes a very different approach. We have a category called significant data fiduciary, which no other country has. There are criteria on what significant data fiduciaries will be, and that will be notified when time comes. But some of the criteria are already known, because these criteria can be taken up from the significant social media intermediaries. How have they been defined under the IT intermediary rules? So for example, if you process data of 50 lakh people, you become a significant data fiduciary. If you process sensitive data on a large scale, you become a sensitive, and etc. And I think most of the organizations have to think themselves as a significant data fiduciary, not as that they are not significant data fiduciaries. Because if you are not a significant data fiduciary today, very soon you will become significant data fiduciary. So you'll have to prepare yourself as if you are a significant data fiduciary and ensure compliance accordingly. The obligation of data processors. DPDPA does not talk about any obligation of data processor. It's very silent, exempt. The GDPR, however, and other global laws also, including the California laws and Singapore laws, have some obligation for data processors if they result in a violation and breach. Here, everything ends with the data fiduciary or the data controller, not any data fiduciary. So it's a very remarkable shift on how these things are being thought about. The notice for consent. As per DPDPA, you only have to take notice when you provide notice only when you are taking consent. But for other legal users, like legitimate use of data, the other legal basis, there is no requirement for taking consent and no notice has to be provided. The breach notification requirements. Here, the DPDPA says that you have to notify breaches to both the Data Protection Board and the data fiduciary. You don't have to make a classification at all. It says any data breach you have to notify directly. Doesn't matter whether it is an email or phone number or your sensitive credit card information or your personal biographic details, biometrics, etc. Any detail you have to notify. The GDPR and other laws talk about taking a risk-based approach, that organizations have to do a risk assessment and see whether the threshold of data breach matches a risk that requires notification to the data principals or the data subjects. So not every breach in GDPRs require notification to the data subjects or end users, but this law does require that. The rights of principal. New rights are added in this law. Right to nominate an individual. And it's not just a right for a user. You can nominate anyone to have rights to access your account post someone's demise. You can have someone to take care of your digital data and well-being while you are incapacitated or not in a position to operate your digital profiles, etc. So very significant improvements. But that also means that all the data fiduciaries and significant data fiduciaries have to incorporate a mechanism, build processes, tools and solutions that allow individual to exercise that right. And that has to be done for every process. So while it is not considered one of the important aspects, but that requires a fundamental design shift in thinking on how your processes have to be defined, because it's now a recognized legal right under the law. But right to data portability and other laws are not being covered under the DPDPA. Earlier versions had, but these versions did not. The data retention. Organizations can retain data as per lawful basis. No retention period is defined. However, importantly, the GDPR says organizations have to justify why they are retaining data for certain purposes. You have to record a justification. Here, there is nothing required. If there are sectoral laws telling you that you retain data, RBI tells you retain data for 7 years, Telecom tells you retain data for 10 years, those retention period will apply. But otherwise, there is no by default de facto data retention period. However, organizations must ensure that since these requirements are anyway going to be defined under the new rules and sectoral regulators have to come up with rules, so they have to prepare, one, the data categorization and inventorization of their operations, the data erasure, how do you erase data after a significant period is served, etc. All those things have to be taken care of. So it's not just like, it requires a fundamental process rethinking from an organization's part. How do they operationalize this? Because then it becomes a non-compliant issue, and you have heard the penalties of like 250 crores being talked about. Then we are going to talk about data flows. I think we already discussed the negative list on data flows. Otherwise, it's a very liberal regime. Any data fiduciary can transfer data to anywhere. Children's data, specific emphasis. Anyone below 18 years and processing of their data. Very restrictive processing. However, rules that will come will provide for some exemptions. But again, very restrictive processing requirements that have been inbuilt as part of this DPDPA. The targeted advertising on children's, your behavioral profiling, etc. It's a de facto ban on that happening. And then you see concepts like consent manager being introduced in the DPDPA. No other law has consent manager, but DPDPA introduces that as a concept. It exempts publicly available data, something that we were discussing on the panel yesterday. So the data which you as a user put out in a public domain, let's say your Facebook page or Instagram, and if somebody uses that data, scrapes that data, then that data is exempt from application of DPDPA. Strange, but if we want to restrict the scraping of publicly available data, misuse of AI and training their systems with like data hoarding, this law does the actual opposite. It actually exempts all purposes. And then grievance redressal, again, one of the important aspects we emphasize in this law, which you won't find in others. Tiers of grievance redressal being built in. And it doesn't start with DPDPA. If you look at the IT rules that came out for the intermediaries, social significant intermediaries, etc., layers of grievance redressal mechanisms are being built in through the Government Advisory Committee, here through the Data Protection Board, etc. So, on the last slide, I want to talk about the compliance aspect. From an organization viewpoint, what needs to be done? Organizations need to have a data map. Understand, identify where each team functions interact with personal data. They need a significant notice refresh because the requirement of what notice requires and has to be served in multiple languages, 22, as provided in the 8th schedule of the Constitution. So that requires a significant refresh. You have to provide details of grievance officer, you have to provide details of with whom you are going to share data, etc. All those things have to be taken care of. You have to revisit your user interfaces, identify where to show pop-up notices, checkboxes. The processor contract review. Now, since controller or fiduciary is the one who is responsible, they have to renegotiate everything, every contract with the data processor. So all the existing contracts which require data processing have to undergo a shift. We have more than 6 crore MSMEs in this country, large organizations, businesses that we are getting from abroad. So just imagine the amount of churn that would require when this law and enforcement takes effect. It's a huge, huge task. Training of employees across businesses, sales, your HR department, finance, legal, etc. Because data protection is not one person's job in the company, it is everyone's responsibility. Although there are no criminal provisions, however, the civil penalties are significantly huge in the organizations, and organizations have to be wary. They have to take care that they are not under the fire by the Data Protection Board. The law allows you to also sanction data fiduciaries if they are in repetitive violations. So imagine your services being stopped. E-commerce company cannot function for 3 days because your data was breached 3 times. These things are also possible because the law allows that provision. All organizations require reasonable security audits, not just security audits. The large organizations, significant data fiduciaries also have to do privacy audits. Annual audits are required. So it's a very important aspect. The InfoSec documentation. All organizations have to be up to date with the documentation part. MSME specifically had this challenge, but now there is no other option. You have to prepare, have everything documented in line to show that what you are doing to uphold your security and data protection practices as required by law. And the appointments have to be made. So an organization has to appoint a grievance officer, a data protection officer, and data auditors have to be appointed for significant data fiduciaries. We discussed about data breach reporting obligations. So you have to notify to the Data Protection Board, the data subject or the data principal, and also to c0c0n, because every cyber incident has to be reported to c0c0n. For banks, you also have to notify to RBI, financial cert, and layers and layers. So this builds on what is being required to be done. And grievance redressal. If you have grievances against companies' misconduct of handling your personal information, then you can approach the company first. If you're not satisfied, you go to the Data Protection Board. If you're not satisfied, go to the Appellate Committee, which is TDSAT. And if you're not satisfied, Supreme Court. Layers of hierarchy being formed. Thank you for this of your time.